My panel discussed the essential facility doctrine, both from the US and the EU, and the conditions under which the requirement that an asset is indispensable is essential for the imposition of access remedies. So my key points were that, in a sense, as a regulator, we have a way of regulating access which does not necessarily require to demonstrate this indispensability, but rather regulating towards making sure that the market becomes competitive. So having a way of doing an assessment which is forward-looking, which we do on the basis of an assessment of what we call SMP, significant market power. Now, the question is whether in the new digital markets regulation proposals there will be a similar type of regulation, similar requirements. The new proposals being developed in the UK for regulation of digital markets consider a test of strategic market status, which is somehow similar to SMP. However, it goes further in terms of considering what is an entrenched position of market power in an attempt to consider what would be required to then make that market competitive and then develop rules which attempt to achieve that goal. The key point which I concluded on was really a question rather than any kind of firm point, which is that markets have changed so much in terms of the way the ecosystems monetize their services, the way they work, and more importantly, the way they're able to manipulate consumers' preferences, which was really the kind of basic tenet of our traditional case law and regulation. So bringing me to question to what extent is case law still applicable, and whether we need to think about new rules to deal with these markets.